57. Amendment of bylaws. A motion to amend the bylaws is a particular case of the motion to amend something previously adopted. 35. It is therefore a main motion, and it is subject to the same rules as other main motions with the following exceptions. Special requirements for this motion's adoption should be specified in the bylaws, and they should always include at least notice and a 2/3 vote, which, with the vote of a majority of the entire membership as an allowable alternative, are the requirements for its adoption if such specification in the bylaws is neglected. See 5650 through 56. 2. Permissible primary and secondary amendment of the motion to amend the bylaws is usually limited by the extent of change for which notice was given, as explained below. 3. An affirmative vote on the motion to amend the bylaws cannot be reconsidered. 37. 4. The rule that when a main motion is adopted, no other conflicting main motion is thereafter in order is not applicable to the motion to amend the bylaws, since several notices of proposals representing different approaches to this problem may have been given, and all such bylaw amendments are entitled to be considered. See 57.6 through 8. Method of handling bylaw amendments. The extensiveness of amendments to the bylaws will determine the method of handling them as follows. Isolated changes. If only an isolated change is to be made in the bylaws, it can be treated as any motion to amend something previously adopted. 35. Subject to the particular rules indicated immediately above. When a series of isolated changes to the bylaws are needed to achieve one end, such as abolishing the office of historian and eliminating all references to it, the changes should be offered in a single motion. If the changes are related in such a way that all of the individual amendments must be made, if any one of them is made, in order for the bylaws to be coherent, then the motion cannot be divided. See 27.5. Sometimes a more extensive change is proposed involving the substitution of an entire section, group of sections, or article. In such a case, often only a few separated passages are actually involved in the change, and they are offered in the form of a single proposed substitute in order to avoid time-consuming separate action on each change. The text of the substitute should then be given with the notice of proposed amendment, or the notice should delineate each of the actual changes, and only changes within the scope of those contained in the substitute can be considered. Portions of the substitute which remain as in the existing version cannot be amended, since they involve areas for which no notice of proposed change was given. General revisions. Changes of the bylaws that are so extensive in general that they are scattered throughout the bylaws should be effected through the substitution of an entirely new set of bylaws, called a revision. Notice of such a revision is notice that a new document will be submitted that will be open to amendment as fully as if the society were adopting bylaws for the first time. In other words, in the case of a revision, the Assembly is not confined to consideration of only the points of change included in the proposed revision as submitted by the committee that has drafted it. The revision can be perfected by first-degree and second-degree amendments, but as as in the case of any other bylaw amendment, the old document is not pending, and therefore, while the revision can be rejected altogether, leaving the old bylaws intact, the old document cannot be altered with a view to retaining it in a changed form. Consideration of a revision of the bylaws is in order only when prepared by a committee that has been properly authorized to draft it, either by the membership or by an executive board that has the power to refer such matters to a committee. Note: a proposal to substitute a new set of bylaws that is submitted by anyone other than such an authorized committee is not improper, but it is not treated as a general revision. In such a case, only changes within the scope of those contained in the substitute can be considered, as described in the previous paragraph 57.4. Back to reading. Procedure of consideration. A revision of bylaws or a lengthy amendment involving more than one section should be considered seriatim as described in 28. If notice is given of several amendments which conflicts that all cannot be given effect, the chair should arrange them in a logical order, much as in the case of filling blanks. 12. Generally taking the least inclusive amendment first and the most inclusive last, so that the last one adopted is given effect. That arrangement of the amendments can be altered by the Assembly. A motion to rearrange the amendments requires a second, is not debatable, is amendable, and requires a majority vote. An affirmative vote adopting such an arrangement is not subject to a motion to reconsider, nor may a later separate amendment be offered as a substitute for a pending one. However, as already stated in 57.1.4, all bylaw amendments of which notice was given are entitled to be considered as a matter of the rights of their proposers, and a bylaw amendment is not dropped simply because it would not conflict with one previously adopted. This procedure does not violate the normal parliamentary rule as might appear, because when any bylaw amendment is adopted, that amendment becomes a part of the bylaws immediately, and it is the bylaw language as thus amended, rather than the previous language, which any bylaw amendment subsequently considered would now propose to modify. If an amendment that has not been considered no longer presents a rational proposition because it was applicable only to language which has disappeared from the bylaws in this process, such a bylaw amendment must of course be dropped, but this situation should generally not arise if the amendments are taken up in proper order as indicated above. The final vote on a bylaw amendment should be counted and recorded in the minutes unless it is nearly unanimous. Amending a proposed amendment to the bylaws. While amendments to a proposed bylaw amendment can be made in both the first and the second degrees, as applicable, and can be adopted by a majority vote without notice, they are subject to restrictions on the extent of the changes they propose. If the bylaws require previous notice for their amendment, as they should, or if they do not, but notice has been given and a majority of the entire membership is not present, no amendment to a bylaw amendment is in order that increases the modification of the article or provision to be amended. See 35(2)(6). This restriction prevents members from proposing a slight change and then taking advantage of absent members by moving a greater one as an amendment to the amendment. Thus, if the bylaws place the annual dues of members at $10 and an amendment is pending to strike at 10 and insert 25, an amendment to change the 25 to any number between 10 and 25 would be in order, but an amendment to change the number to less than 10 or greater than 25 would not be in order, even with unanimous consent. Had notice been given that it was proposed to increase the dues to more than $25 or to reduce them below $10, members who oppose such a change might have attended the meeting to vote against the amendment. The same principle applies to an amendment in the nature of a substitute for sections or articles, short of a revision, as already indicated above. The proposed substitute is open to amendments that diminish the amount of change, but not to amendments that increase it or that introduce new changes. Thus, if an amendment is pending to substitute a new rule for one that prescribes the initiation fee and the annual dues, and the substitute proposes to alter the initiation fee but does not propose any change in the annual dues, then an amendment which recommends changing the annual dues would not be in order. Amendments to strike out a sentence, paragraph, or section deserve special care. In such cases, the existing bylaw is not itself open to consideration, but only the amendment. If notice is given to strike out a provision of the bylaws and some members feel it should be retained with certain changes whose substance would be outside the scope of that notice, those members should immediately give notice of the amendments, the existing provisions which they think are advisable. Otherwise, friends of the existing provision will be cut off from the opportunity to work out compromises for its partial retention by perfecting the existing language. Giving notice of amendments. Notice of a bylaw amendment should be formally worded in a form such as to amend Article 4, Section 2 by striking out March and inserting April after the word second Tuesday in. When the bylaws do not place a limitation on those who can give notice of a bylaw amendment, any member is entitled to do so. If notice is to be given at a meeting, this is usually done under new business, although it can be done at any time, even after it has been voted to adjourn if the chair has not actually declared the meeting adjourned. A bylaws committee can give notice in the part of the order of business set aside for committee reports. If notice is to be sent with the call of the meeting at which the amendment will be introduced, the society is responsible for paying the cost of sending such notice, not the member proposing the amendment. The notice should fairly inform the members of the changes contemplated. Showing the existing bylaw and the bylaw with the proposed changes in parallel columns is a good device so long as the exact amendment, stated in a formal manner, is set out at the top across both columns. When notice of a bylaw amendment is given in open meeting, it cannot be considered at that time, except to be discussed informally and briefly at the discretion of the presiding officer. See also 43, 31 through 34. Time at which a bylaw amendment takes effect. An amendment to the bylaws goes into effect immediately upon its adoption unless the motion to adopt specifies another time for its becoming effective, or the Assembly has set such a time by a previously adopted motion. While the amendment is pending, a motion can be made to amend the enacting words of the motion to amend by adding a clause such as this, with the proviso that, or provided however that, this amendment shall not go into effect until after the close of this annual meeting. Or, while the amendment is pending, an incidental motion can be adopted that in the event of the amendment's adoption, it shall not take effect until a specified time. Either method requires only a majority vote. It is a mistake to encumber the bylaws themselves with provisions which have effect for only a limited time. If the mechanics of transition to operation under a revised set of bylaws will be complicated in ways for which the act of adoption must provide temporarily, such provisions can be numbered and attached to the revision draft on a separate sheet headed provisos relating to transition. The motion to adopt the revision can then be made in this form. I move the adoption of the revised bylaws with the provisos attached thereto. Amendments to the article on officers may raise difficulties in relation to the time at which adopted changes take effect, unless special care is taken. A society can, for example, amend its bylaws so as to affect the emoluments and duties of the officers already elected, or even to abolish an office, and if it is desired that the amendment should not affect officers already elected, a motion so specifying should be adopted before voting on the amendment, or the motion to amend can have added to it the proviso that it shall not affect officers already elected. There is virtually a contract between a society and its officers, and while to some extent action can be taken by either party to modify or even terminate the contract, such action must be taken with reasonable consideration for the other party. It is important to note that, although the time when a bylaw amendment takes effect can be delayed by the Assembly, the amendment becomes part of the bylaws immediately upon adoption. If the amended bylaws are printed, a footnote or similar device should indicate that the amended language is not yet in effect, and if language was removed by the amendment, the text of that provision should be given if it is still applicable in the organization. Captions, headings, and article and section numbers. It was formerly customary to print permit the Secretary to fill in captions, headings, and articles, section or paragraph numbers, or letters, and the like, after the Assembly had adopted bylaws or other long documents. Such designations were treated as mere marginal notations which could be clerically modified. It is now the usual practice to include these subtitles or identifying numbers or letters as an integral part of what is adopted by action of this Assembly. In the process of amending previously adopted documents of this kind, indisputably necessary changes in designation by number or letter may be presumed to have been included in the Assembly's action, even if they were not mentioned. For example, if an Assembly adopts a motion to insert after Article 3 a new Article 4 reading as follows, the Secretary or a committee would of course raise the numerical designation of each of the later articles by 1, even if the enacting motion made no reference to doing so. Only the Assembly can amend captions or headings under the rules applicable to bylaws or other papers if such change could have any effect on meaning, and this authority may not be delegated. Corrections of article or section numbers or cross-references that cannot result in a change of meaning can be delegated, however, to the Secretary or, in more involved cases, to a committee. An Assembly may delegate its authority in this connection in a particular case by adopting, for example, a resolution such as the following. Resolved that the Secretary or the blank committee be authorized to correct article and section designations, punctuation, and cross-references, and to make such other technical and conforming changes as may be necessary to reflect the intent of the Society in connection with blank.